So good afternoon, ladies and gentlemen. My name is Walter Kemp from the OSCE. Paul's advice this morning was to keep you informed, keep you on time, and keep you smiling. I'll hope to do at least 2 out of the 3. This is being live streamed, and like in the British Parliament, if you move closer to the camera, it looks like the house is fuller. So particularly if you're on the sides, if you could go from the margins to the mainstream, I mean, you're welcome to continue sitting on the side, but it looks more impressive on TV if there are more people in the middle. Plus, you can see the panelists better, and it's easier for the moderator if you have any questions. So this is very often the hardest panel to be on because it's just after lunch. But luckily, it's the core topic, human rights-centered approach to rapid technological change, which is the topic of the event, after all. And we are lucky to have with us a great group of panelists and also a moderator from ODIHR, David Mark, who's a human rights advisor. And I'd just like to repeat again how appreciative we are of the cooperation with ODIHR in organizing this event. So, also, this is on Twitter for those of you who tweet, if you'd like to join the discussion at the hashtag SecDays. I'm not on Twitter, but please, if you are interested, join the discussion. So now, David, over to you. Thanks.
So much for the kind introduction. Indeed, it's just after lunch, but I think we're going to have quite some interesting things to talk about with you and with our distinguished panelists. So first of all, let me introduce them. We have Carmen Turk, who's a lecturer at the University of Tartu in Estonia. She's also a lawyer, an attorney. And she's passionate about AI, automation, and legal issues around that. And she's also an expert on the European Commission's high-level group on that. We also have, just next to me, Barbora Bukowska. She's a senior director for law and policy at Article 19, an organization we all know working on freedom of expression. She's, I would say, maybe a human rights defender with quite a lot of experience in defending rights, and with many cases, I understand, of the European Court of Human Rights and with a lot of work in human rights. We also have George Krivokapic, who's an assistant professor at the University of Belgrade. And I also know that he is I would say, a digital rights activist and the founder of SHARE, a foundation from Belgrade, from Serbia, working on digital rights. And finally, we have Beatrice Balbin, who we know. Welcome back, Beatrice. She's the chief of special procedures branch of the Office of the High Commissioner for Human Rights. And she's been working for the UN for quite a long time, in Africa, in Balkans, in Latin America, and so on. And she served with us as our deputy director at ODIHR. So we have quite a lot of knowledge here on this panel, and I will try to, for your benefit, to get as much out of that as possible. So without further ado, I want to start with a general question for you. And it's a general question that I think it is relevant for the setting in which we are. And it is related, if you want, to the title of our panel. The title of our panel talks about rapid technological change. And I think it's not a secret or something new for everyone that we do have, the pace of technological innovation is fast. It's really fast. It's so fast, actually, that often we see that politics are catching up after the fact. Yeah? We have maybe companies or we have actors out there which are innovating, which move fast and break things. And then we have maybe unintended consequences, and there's a need for politics to catch up. But at the other side, we have the political system which is, if you want, an innovation of the 18th century. And yet, this political system and governance is the one which is in charge of defending human rights, of promoting, of upholding human rights. It is the state's responsibility, according with human rights law, to protect, respect, and fulfill human rights. So my question to you is related to this. Do you see politics catching up with technology? Is it needed? Maybe it's not needed. And how would you see this happening? And maybe we can delve further then into more subjects. I will start according with the agenda with Carmen.
Good afternoon, everyone. Welcome to this graveyard panel. We'll try to keep you up and merry throughout this hour and a bit, yes. So you want a short answer, or I give like...
Let's try a medium length answer.
Medium length answer, so 3 minutes. Something like that. Okay, so I have my 3 minutes. For these 3 minutes to be fruitful for everyone, just to lay the ground that I will give a perspective from the view of whether the positive obligations of the state are being fulfilled vis-a-vis the rapid technological change. So what I'm going to address is not the software, not the if-then software from the technological point of view, and I'm not going to address the utopian general artificial intelligence that you may see from the movies. So I'm going to address the issues that have been emerging in terms of narrow AI, so the expert system AI that we are all eager to use in public sector and private sector alike. We use it for customer experience enhancement. We use it for pattern analysis in order to make sense from the vast amount of data that is surrounding us. We use it to automate the mundane tasks in our everyday lives, whether in public or private sector. However, these tasks that we are delegating to these autonomous intelligent systems are more often than not from the sector that we see inherently as us being humans. What I mean by this? I mean that, well, we are creating algorithms that create. Creation is something that is very human in nature. They create algorithms, they create poems, photos, journalistic articles, they create deepfakes, videos, so forth. They make decisions on our behalf. They negotiate agreements, they execute agreements. Let's take an example of a Twitter bot, Trump and Dump, which analyzes the tweets from the President of the United States and makes real-time decisions on whether to buy or sell shares of publicly traded companies, just making a decision based on whatever was tweeted about. But furthermore, we delegate them decisions that are ethical in nature. Let's take self-driving, or at least half self-driving vehicles on our streets. Let's take Tesla. We delegate to that machine or a bunch of algorithms a decision that is ethical in essence. Very, very human decision. Let's take a trolley problem, the everlasting philosophical question, who to hit, yes? So we delegate those decisions to algorithms, to machines in essence. So the question is that, well, how does the state's positive obligation in making sure that the environment that we allow this technology to come into is ready for that, so that these machines, these algorithms, are still there for our benefit and not making our life worse than when we started out. So let's take I talk from the example. We all know the Compass case from the United States Supreme Court, which was a judicial algorithm that was suggesting to judges how to sentence, what are the probability of recidivism. When Mr. Loomis went to court saying that, well, but I want to know why the algorithm is making this decision, then the outcome from the Supreme Court was, but this is proprietary. You have no right to know because this is proprietary. So it belongs to a private company, so you just have to face whatever sentencing or recidivism level this algorithm is giving you. We do not, I think, as a society, want this to happen in Europe. So, in my opinion, the international organizations have stepped in to help a bit, the states, but also the actors within the field. We have Commissioner for Human Rights that we heard in the morning, giving out a recommendation regarding AI, mandating that whenever a state is deploying or developing such algorithms, then there would be human rights impact assessment that would be obligatory. We have EU high-level expert group on AI trying to find out, give a toolbox to companies and users alike to assess whether the AI that is being created and let loose in the society, whether it can be trusted, whether it's explainable, whether it's robust in essence. And of course, we have OECD AI principles that have been signed up by, I think, 42 states by now. So I think the international community is starting to fulfill this positive obligation, or at least give guidance to states what we have to do to ensure that in 10 years' time, when we look back, then we know that we did better compared to how we managed the internet governance when the internet started out for the public sphere. So that were my initial thoughts. So I stop here. I know I stop.
Thanks a lot. Actually, interesting examples. You're saying so international organizations and states are starting to connect to this process, to technological processes, and starting to, and there's a bit of a lesson learned, right, from previous examples. Thanks so much. I will ask you now, Barbara, to maybe reflect on the same question.
Yes, I do agree what Carmen just said, because we have actually a lot of examples, and she mentioned quite few of them where the political processes and legislative protection is actually catching up with some of these issues and already been providing solutions. So we have never been in a system where there will be totally anything goes there. But I also want to highlight one more mechanism or one more institution where we need a human rights-centered approach to address the human rights concern in deployment of technologies, and this is the work of technical standard setting bodies. And this is an area which is often overlooked in the fora like OSCE or even human rights discussions, and that's actually where my organization, Article 19, has been doing quite a lot of work, which really stems from what Dunja said in her opening remarks, and also it comes from Melvin Kreitzberg in what he said in 1980s, that technology is neither good nor bad, nor is neutral. And then when technology is not neutral, from perspective of human rights, these technical standards really matter. And what we push for at Article 19 is really promote the development of technology with human rights in mind. And because otherwise, if it's not developed with human rights in mind, human rights will not be protected in deployment of technology. But also, having the human rights design is not enough. You have to have this really holistic approach from product development to the market, which protects human rights. And here I sound maybe like marketing consultant, not as a lawyer, but this is really important. So what we really need and what we are doing is introducing really the human rights considerations in technical standard setting processes, what this means for developers, what this means for programmers, and how they should develop this next generation internet products and technology products with human rights considerations. And what actually we see here as a problem is that there are some good news that a lot of companies are really trying to introduce and bring some tangible results with privacy and human rights protection to their products, but then they are having a push from the political masters and from the states to prevent these good developments. So an example of this is, for example, the attack on end-to-end encryption. Recently, there was a push from the governments of United States, UK, and Australia to Facebook on encryption on their services. So what we see is often this really bizarre struggle between some of the companies who are doing a good work, and actually from even privacy institutions and privacy data protection agencies that tell these companies, be better, protect data, have a better data protection rules, and have the privacy consideration in mind. And if you don't, we will also charge you. We give you a fine of 4% of your annual turnover. And then on the other hand, we have the security agencies who are publishing, angry reports or political reports that our society is being destroyed and terrorism will happen at every corner if the companies don't act on these legislative imperative we have given them. So what I want to say and start with to have a human rights-centered approach is that we really need to get a good policy backing for good technological developments that they deserve, and then also have to have a pushes against the bad technology developments that they deserve.
Thank you so much for that and for sharing your experience about companies already working with to implement human rights. It's interesting what you say, that there's a pushback from the state. Georgia, what's your view on this?
So, as you already explained, we have this great, rapid technological change surrounding us. We have amazing scientific progress, and we have great solutions which will resolve our both social and economic problems. And we see them quite often like a silver bullet for many things. On the other hand, we have this culture of Silicon Valley, go fast and break things, testing solutions, going immediately with minimal viable products, and then doing different experiments, trying to figure out what works and what doesn't. Being like completely turned to risks and then adapting and iterating after there is some pushback. And then we also see that our governments and international organizations and traditional sector are not effective to follow this technological change. And then we have a pressure for digital transformation and for implementation of technology on many levels. And we not only have this pressure to implement technology, but to change the way how we operate and manage the projects in public sector especially, to involve different new technologies and, again, to go fast and break things. And there's a problem because sometimes on a small scale you can try some solutions and the damage will be small and harm will be small, but as we saw some unregulated fields where we left some companies to figure out how they will facilitate our communications or some other aspects of our lives, became some huge monopolies who now have to be teared down and return back to the basics in order to protect our fundamental rights. However, if we let public sector to go fast and break things, it will break our fundamental rights. And that's not something what we want to see. We have many examples that governments and some big, let's say, private-public partnerships are trying to push some technological solutions without proper assessment. And then from a philosophy of Silicon Valley, it's fine. We'll see what's going to happen. Then we'll have some pushback. Then we're going to have some court proceedings. And after 5-10 years, we'll end up in front of the court in Strasbourg, maybe, and then we'll get the decision. So I don't think that's the way to go forward when we face these rapid technological changes. And then can we adapt as policymakers, as somebody who should regulate these things? I don't think it's quite easy. As we know, like process of developing complex new regulations lasts, especially on the level of European Union, for example, from 4 to 6, 7 years. And then we have these big regulations or directives which should have a life of 15 to 25 years. So in order to be successful, we cannot abandon these frameworks, how we develop new regulations, but we need to do more research to understand what we are regulating. We need to do research with interdisciplinary and multi-stakeholder approach in order to be able to assess all the risks which are coming from the technology. We have to deliver long-lasting pieces of legislation and regulation, put much more effort into oversight, how this regulation is implemented, and definitely we'll talk more about that later, put moratorium on some of the technologies which are already here and which are maybe here to stay, but to figure out how they're going to impact our life and life of our citizens.
Thanks so much on that. I wanted to pick up on the iterative process which you mentioned, which is build, test, break, build, test, break. And I do wonder sometimes how can we get, how can we, maybe even as international organizations or policymakers, catch into that. And yeah, maybe we can get back to that. Beatriz, your views on the same question. Are we going to catch up?
David, and thank you for having me back in Vienna. It's a pleasure to see former colleagues again. Having heard from the experts on technological change, I have to acknowledge I'm not an expert on technology, but I would try to contribute to this discussion from the perspective of what the UN as an international organization is contributing to making sure that we try to catch up in protecting, promoting, and respecting human rights while technology has many advantages, as we've heard this morning, as well as challenges. Whether we have caught up already or not, I wouldn't judge myself. I leave it to the audience to see, what else can be done, and I would be very happy to hear from them any recommendations that may be made to the UN in general and the Office of the High Commissioner for Human Rights that I represent here. But as you know, it is not new. Actually, the office has been engaged with, generally speaking, the private sector, but including also ICT companies, and the process goes back to 2005 when there was a request to create a special an SRSG for developing what would be the guiding principles for the private sector and the business and companies to respect human rights, that actually ended up with the adoption of the guiding principles that now apply, and we hope everybody signs up for. Since 2011 when they were adopted. So this is basically the framework with which the UN and the Office of the High Commissioner for Human Rights has been working, and actually there's a lot of work being done by the Office, by the High Commissioner, and also by the special procedures of the Human Rights Council, which is my current function right now, helping them in doing their work as they are mandated by the Human Rights Council. The Office of the High Commissioner for Human Rights has been requested to support them in doing that work, as well as pushing forward the agenda of business that respect human rights and engaging with the private sector. And one example that I can share with you now, and for those interested, information is available on the website, is that the office is now engaging in what it is called the Btech Project, which is basically the business and human rights in technology project, that what it is trying to do is to contribute to address the urgent need that has been voiced by the companies themselves, because now they feel they are more being targeted by human rights workers, but the civil society and by policymakers to find principled and pragmatic ways to prevent human rights violations or address harms that are connected with the development of digital technologies and their use by the corporate sector, by governments, and by everybody, by ourselves. And the premise of this project that the office is now developing is trying to use the lens of the framework of the UN that covers the protect, respect, and remedy, so accountability also and reparation of the UN guiding principles, and try to help and clarify what are the roles that correspond to each one of us, the international organizations, the governments, the private sector, etc. But as I said, it's not only the office, it's also the work of special procedures that have been appointed by the Human Rights Council. And actually, I was recently in Dakar in a retreat of the Human Rights Council, and I was very happy listening to the member states that participated in the retreat, acknowledging the role of special procedures mandate holders actually in pushing the agenda of human rights when it relates to technology, maybe even thinking of it before it was a subject of discussion in places like this one. And there are a number of examples on that. Obviously, I mean, through the work they do, visiting countries, producing reports that they present to the Human Rights Council, but also by producing thematic reports presented to the Human Rights Council and to the General Assembly. And actually, these reports may be coming from mandates that are not the obvious ones. I was discussing with Barbara before this meeting how Article 19 is working with freedom of expression, for example, with David Kay. That's the obvious one because of the topic that we are covering here. But it is not the only mandate that actually has been looking at how technologies may be a force for good or a problem, depending on how they are regulated, they are framed, are they understood properly, and how they are put to good use. So, for example, freedom of expression has presented reports on a number of things, such as challenges to freedom of expressions and how states and private sector respond to those, the role of digital access providers, online content regulation, AI technologies and implication for the information environment, private surveillance, and so on and so forth. But then you have other mandates that are not the obvious ones, like, for example, the Special Rapporteur on Cultural Rights, which would not come immediately to mind as somebody who is actually pushing the agenda of how to make sure that human rights are respected in this developing and changing world when it comes to technologies. So she's covered some of these aspects on her reports about cultural rights on public spaces, or the impact of extremism on the cultural rights of women, and how the implications of new technologies. Same thing, the very recent report from Philip Alston, the Special Rapporteur of Extreme Poverty, to the General Assembly. Just now, in the last session, it was on the digital welfare state, and what are the risks, and how it affects poverty, and people who live in poverty. But also reports from the Rapporteur on Freedom of Assembly and Association, or going back to 2014, mandate on racism already provided reports on the manifestations of racism on the internet and social media, among others. So that's why I'm saying this. We are talking back more than 10 years that the UN and the Office of the High Commissioner and the mandate holders have been looking into this. Does it mean that we're doing enough? That we have caught up with this very, very fast pace? That's for the audience maybe to provide me feedback and inspire us on what would be the next steps. As we go through this discussion, I may share more examples. Thank you, David.
Thank you, Beatrice. Actually, I was just thinking, we were sharing around our office the Special Rapporteur's report, the one on extreme poverty and human rights, and with a quote-unquote, technology companies often work in a human rights free space. So that engendered even a conversation among us and the colleagues there about this. Beatrice, I will want to thank you for that, but I will want to dig a bit deeper and ask you a few more questions. You mentioned a lot of the work you do, but do you think it's sufficient? And more exactly, I would say, do you think the framework, the human rights framework as we have it now with conventions and the declarations and so on, is this sufficient now to use it, let's say, as an assessment tool for digital innovation, or do we need more? Do you think there's need for more?
Continue here. Thank you very much. I would like to start by quoting the Secretary General on something that he said recently, because the UN Guiding Principles that I mentioned on business and human rights and how it applies to the ICT sector actually provides quite a comprehensive and authoritative framework already. Not legally binding in itself, but it is anchored on legally binding instruments that member states have actually ratified. And so the central role that the guiding principles and the need for guidance on their application in the context of digital technologies were recognized in the report of the Secretary General, the high-level panel report on digital cooperation, and I read and I quote what he said: the roles of government and business are described in the 2011 UN Guiding Principles on Business and Human Rights. Though not binding, they were unanimously endorsed by the Human Rights Council and the UN General Assembly. They affirmed that while states have the duty to protect rights and provide remedies, businesses also have a responsibility to respect human rights, evaluate risks, and assess the human rights impact of their actions. There is now a need for clear guidance about what should be expected on human rights from private companies, as they develop and deploy digital technologies. And this is quoting the Secretary General. Now, whether more guidance, legal frameworks are required. I mean, there are obviously legislation at national level that it is supposed to be respectful of international commitments and engagements made by member states when joining the binding documents and treaties that they have signed. But there is no consensus, even if when I discuss with rapporteurs of the Human Rights Council, whether do we need more regulatory framework, do we need less, is it enough? And basically we should stick what we have already. There were discussion among panelists before coming here, and I would imagine that they are going to go back to this, is self-regulation enough? And should we just be happy with that, or should we advocate for something else? And actually, if you have the opportunity to look at the reports produced by rapporteurs on this topic and the High Commissioner and the Secretary General, there are a number of concerns as to whether the framework is enough or not, and a number of recommendations. Now, some of the concerns or the gaps that have been identified cover areas like, for example, the framework and mechanisms they are not really mechanisms to enforce the existing legislation or the existing framework when the private sector decides not to, go by the guiding principles, for example, or that some international instruments do not cover new problems that have been identified because of this very fast pace that you were mentioning before, David, or that domestic legislation is not keeping pace with the actual developments in technology, but also the international framework that has been developed, or the lack of clarity as to whether companies actually protect the rights of their users, or that states give companies legal incentives to do so, or should they do it? So there are a number of gaps that actually have been identified. To address some of those gaps, these same special procedures and experts provide ideas of things that should be done either by states, the international organizations, or the private sector themselves, like adopting legal and policy frameworks that tend to improve regulation and accountability and transparency. Also how to regulate, how to provide remedy when violations have already occurred because there was not a preventive action when deploying these new technologies and developing them. Developing codes of ethics and accompanying institutional structures that complement but do not substitute for the human rights commitments that have already been signed to by member states. Establishing oversight watchdogs or mechanisms that are outside the private sector and how to regulate those, or even create more standards. Are they necessary, or the ones that we have are enough? Or a more comprehensive and harmonized use of terms and the understanding of them with governmental authorities, oversight bodies, judiciary, do we have to get them involved, political parties, legislative, civil society, and obviously researchers and the corporations, the private sector itself. There are many other recommendations. I have a very long list that I'm not going to go through, but I think that they actually provide very good ideas and avenues that could be followed to decide whether regulation that exists already is enough, or should we continue pushing the boundaries and maybe taking it further. Thank you.
Thanks for that. I see that Carmen has a reaction to that. So,
the question was, is that enough that we are now developing on the international level? I'm sure it's not enough, but I think it's a good first step, because this would give especially politicians, because legal policy is something that is always reactive. We are so slow as lawyers. We always wait for something to blow up before we even think of doing something. So we lawyers, we tend to be very slow. So these legal international initiatives giving us an idea what to do or where to step, which way to go, that we should think human rights by design, ethics by design, robustness through the life cycle of a service that could go on for years. I think this is very, very important to give the states encouragement to actually enact legal obligations. For example, I come from a quite tech-savvy country, small country, Estonia, and we tend to maybe sometimes do a bit of Silicon Valley thing that, well, let's break it and let's try to mend it quickly and then we'll see forward. But it has also given us a huge edge in being brave enough to we are considering at this moment to be a first European country to have it in a law as a legal obligation for private sector or public sector alike before deploying or developing any service or any product that is autonomous and intelligent. Would have to go through the human rights impact assessment. To have this as a legal norm, you cannot deploy it to public before you have done it. You have published it, it's transparent, it is through the life cycle, it is regular, and you have legal obligation to do that. I think this is what these international initiatives have given to the states to take those actual positive obligation steps towards trying to make this environment 10 years looking back, viable and sustainable. If it's too late, I would rather say that we are already late, but at least I think later is better than never.
Any reaction on the same? No? I will react. It's for me, this is interesting what you're saying, because if we look at other sectors, say pharmaceuticals or even biotech, which is another very interesting area to follow, you see that somehow in those sectors, the system is there to protect citizens, to make sure that what is put on the market is okay, it's not going to harm us, and so on and so forth. And to a certain degree that works. There's even UN agencies in that sense. So just my reflection on that. I'd like to ask, turn to you, Barbara, now, and talk a bit maybe about freedom of expression. Maybe you agree with me that freedom of expression as we knew it when, say, the ICCPR was adopted is a very different thing from what we have now, right? I mean, any of us can take a mobile phone, start filming, make something, get to, I don't know, thousands, hundreds of thousands, even millions of followers, and put ideas out there. Do you see challenges in this, or is this fine?
International human rights standards are broad enough to capture this broad range of technologies that are there, and they were actually developed with that in mind. Because if you look at, let's say, Article 19 of ICCPR, International Covenant on Civil and Political Rights, it talks about any means of communication there. So that can be a technology as well. But what I think here is what we are facing challenges here are numerous for freedom of expression. But what I want to highlight are three things. First one is something which has been already discussed in the previous panel, and I think Jacob spoke extensively about, introducing restrictions on the basis of incomplete research and incomplete knowledge of the problems in the situation, and having this knee-jerk approach to restrictions for issues such as misinformation or hate speech and so on. And this is not to say that these concerns are in vain or they are not there, but too much focus on restrictions, rather than what really are really deep considerations in deployment of this technology for free speech is the issues such as sustainability of journalism, but also what does it mean pluralism and to have a pluralism and diversity online. Because often what is forgotten is that states have a positive obligation not only not to restrict freedom of expression in excessive way, but also they have a positive obligation to ensure pluralism and diversity online. And this obligation is actually challenged by the business model of many of these companies. So let's say social media companies, because their business model is based on advertising, which does not encourage pluralism and diversity. It's based on, and what these companies expose us to is not all the possible content that is out there, but only a very, very small fraction which they profile to us and which they show us. And that's the content which will keep us engaged because they can monetize it then for the advertising. So from a business perspective, it's not really conducive to these companies to expose us to the diversity which is there, but not to do so. And this is really a challenge for legislators and policymakers, how to achieve this. And this can be done actually through a lot of tools which are omitted, such as look at competition authorities, what competition authorities are doing, and even for issues such as what we call vertical separation or unbundling of such services, and obliging these companies to, let's say, open their IPI protocol to competition and provide much more diverse entities for content moderation, but also for profiling certain content. So that's number one. Then second is what is a huge concern to freedom of expression, and that's what was already mentioned by George, is the dual use of technologies, a regulation of the dual use. There are a lot of emphasis on export of these technologies and selling them to, countries which are not friendly to human rights, but what is forgotten is internal usage. So internal usage of dual use technology. And here we see that really surveillance techniques, equipment interference, which is so-called government hacking, is being deployed by the governments to target human rights defenders, to target journalists, and to target those who are political adversaries with impunity. And Georgi also mentioned the biotech or the facial recognitions, which really has emerged as a really strong problem and consideration for protection of human rights in many areas of what we do, not only online, but how the technology impacts us, what we do offline, let's say for organizing protests or even engaging in the civic space. So we really, and I really support his what he already called to introduce moratorium on deployment of such technologies before they can be audited, and before we can ensure from a human rights perspective that these human rights safeguards and the rule of law are introduced. And this is not just obligation for the companies, and as I said before, we already work with the tech sector or with technical standard setting bodies on building this human rights consideration to standard, but also allowing the governments to use these technologies towards their own citizens or people who live on their territories.
Georgia?
For these comments, I will just continue and tell you one story about a rapid implementation of technology without human rights-centered approach. I come from Belgrade, and in Belgrade a couple of years ago, there was like really interesting hit-and-run accident on a bridge. The young guy in a fancy car killed regular citizen and run away. And that was outrageous in the public, and there was a huge public pressure, and then police did the work. So they took all the video surveillance footages. They also took all the telecommunication metadata from that bridge. That night they interviewed hundreds of people, and finally they found the identity of the guy who did it. They couldn't find the fancy car. They disappeared. But then they determined that the guy ran to China in the meantime. So they sent the photo to their Chinese friends, and in 48 hours, the guy was recognized on the street, arrested, and sent back to Serbia. So Serbian police was very happy. They resolved the case. And they also went to say thank you to Chinese friends who also provided insight in how they found Serbian guy in billion people China. And I suppose some people here have been to China in the last couple of years, and you could see this huge technological change there, which has an amazing impact on a society, that safety there is completely different, and the feeling, you really have the feeling that you are safe, regardless of the fact that it's completely different culture, everything is on other language, everything is different, but you feel safe, like you don't feel safe in European cities. So they said, okay, let's take this safety back home, and let's take the technology and cameras to Belgrade. So they said we will implement 100 smart cameras, 1,000 smart cameras, 2,000 smart cameras in Belgrade in just a couple of months. So we started to follow the story, sent many requests to the government based on freedom of information, public procurement, and so on, and we were rejected on all the requests because it's a national security, public security question, and so on. However, Huawei, the Chinese company, put all the information about the project in Belgrade on their website because for them, it's a success story. They're implementing their software and their solution in Europe, and it's a really important case for them to prove that they can They can just deliver solutions all around the world. However, then after we publish the information from a website saying that it's going to have like big number of cameras covering whole city with facial recognition, with the behavioral analysis, with the infrared car plates detection, and many other capabilities for integration with other systems and so on, that information also disappeared. Then we said, okay, we have a new law on data protection, and that law is same like GDPR and a police directive in EU, and you need to do impact assessment, and started pushing that idea. And what was great, thanks to these regulations, we really got last week the impact assessment, data protection impact assessment of this surveillance system in Belgrade. And that's the first time we really got some information from the government what's going to happen. But how to say, it's a first kind of impact assessment we got in Serbia. It's still just trying to figure out how the video surveillance will work, but not going deeply into smart technology, visual recognition, facial recognition, and so on. So it's not something what can properly assess the risks which are coming. So what's the problem here? Implementing such solution in a city will completely change the way how the police can and the government can approach citizens. It's a solution which can match the type of car, the identity of the person, and then, for example, collect data from tax authority and assess is that person is earning enough money to drive that car on the street. And maybe if not, start some process of investigation. That's very illustrative example. We can talk more about how the dissidents protest, right to assembly, right to expression be breached, but it's really hard to fight these processes which are completely changing the social contract we have regarding public spaces. And at the end, we also have to understand that this technology which is implemented is not developed under human rights-centered approach. This technology is developed in China without basic understanding of privacy rights of Chinese citizens. The data which are gathered and used for training of these algorithms are usually breaking some of the standards of human rights. And there is also a question in relation to the foreign trade and import of such technology. Should we allow import of technology which is developed on different standards, because it's unlawful competition maybe to our companies who are doing everything great. So in general, that's why without really proper understanding how many aspects of our life will be changed in the future, especially considering the connection of these kind of systems with other databases in public and private sector, it's really hard to go forward and say, let's have this Chinese safety in our city.
Thanks for that. There's more pieces of technology being imported. I don't know, maybe it was touched here already, fifth generation connectivity on mobile and the issues around that. I want to make a bridge between, you were talking a lot about facial recognition, about surveillance. Often this is automated, right? It's computers behind doing a lot of the sorting and selection, let's say. I will pass to you, Carmen, with a more general question. You're an expert in automation, AI. You see many of the things that are being now, let's say, in the labs, are being cooked in the labs of various actors. What would be the key issues that we need to look at in order to make sure that we get more the benefits of this rather than the potential harm?
I guess the moment when the policymakers start grasping the idea that the technology that we actually talk about here and what we worry about is not on the level of a very smart refrigerator, yes, ordering you new carrots when you're out of carrots. We are talking about technology that is going to change the fabric of our society, the fabric of how humans live together on this planet. That this is not a technology that the outcome you can predict. The technology is, we call it autonomous and intelligent only because of one thing, that it is able to reach conclusions that surprise us, that are doing that better than us. And I think the moment we grasp that as policymakers and start thinking that, well, just because the machine is really, really smart, it doesn't really give it any reason to believe that, well, since it is smart, then obviously it doesn't have biases. It obviously is able to make difference between important and not important things. It obviously knows what human rights are, so of course they are going to make decisions that are ethically acceptable to us. When we teach this understanding that we tend to have, because this is how we see technology today. We have Microsoft Word that is doing exactly what we tell them, even so they are writing it better than us with our pencil. So we tend to trust this technology, but I think the trust is not earned just by being technology, but trust has to be earned by the obligations that are fulfilled by the private sector and public sector that are deploying such technologies. Of course, we have to be very careful not to anyhow hinder the real innovation that would bring our society to the next step, but we have to put boundaries that we want before deployment, before giving this technology to the public use. We want some pieces of the puzzle have to be fulfilled through impact assessment and through other paths from ethical and human rights perspective.
Thanks a lot for that. I kind of caught on outcome. There are not outcomes that we can predict or that we can see, and I think so far this has been quite true. Maybe now there's more, and I think this is what I gathered from the panel, there's more work in trying to predict, or at least in trying to think about what the outcomes of this type of new tech is going to produce. I want to maybe go a bit on a scenario with all of you and with the participants here. And I believe it's not a scenario that is very, very, very far, and it kind of connects to what you were just talking about. So let's imagine Vienna, let's say 10 years from now. I think we're giving it a good time for that, and that we have in Vienna a lot of technology, automated technology, particularly transportation, for example. Imagine that we have cars which are autonomous, which are taking our kids to school on their own, which are coming to pick us up, which maybe we can send away to take other people to their workplace and so on. Let's even imagine, because we are maybe thinking about an environment, they are also electric. But this maybe it looks like an utopian scenario, but it could also very quickly transform into a nightmare. So my question to you is, like, what happens? What are maybe and not only the human rights implications. I'm going here a bit more towards security as a topic for our meeting. Could you think about this scenario and share with us what would be the implications from your perspective as experts in this? Shall we start here with Barbara?
Okay. So my first consideration or my first question would be for I assume the city of Vienna, who automated all its public transport or allowed this to operate, whether there has been public discussion about the deployment of this, and whether we really have a discussion and honest and full discussion within the society on the need of these technologies, and also whether we really need to deploy them for making our lives better, because this is often missing. So often we just get let's say benefits of it, or the discussion is presented in very skewed narratives. So, for example, on the surveillance, that it's necessary to prevent criminal behavior and it's gonna stop everything, but it's not presented in a scenario when people would know that, let's say, if government came and checked all your Christmas presents or checked what you are feeding your kids, whether they would be okay with it. And then also whether these processes have been transparent, whether there have been enough considerations for human rights basis of this technology, and to having a discussion rather than just employing this technology because it's available on the market. The technology should never be deployed by the states and public sector only because it's available on the market. Before all of these discussions we have had before, that whether there are human rights protection and safeguards from the rule of law and democratic values in mind.
Thank you so much.
Was that when we have this kind of Vienna and then something bad happens, yes. I think that's the problem in many debates that we especially when you have lawyers in the panel, we tend to get stuck that what happens if somebody hacks it? What happens if there is a malintended person and it's going to take everything down and all the bad things happen? In my opinion, this is not really something that is really a problem to be solved because we have so many institutes in law in all of our countries that would solve that. We have criminal law liability, we have civil law liability, we have strict liability, product liability. So I think the liability issue, it's always somehow drawn into this discussion, but I think this is quite easily solvable within the existing legal framework. But I agree with Barbara that what is not solvable with existing law is this duty of care, not only by producers who develop and deploy these, but also deployers and also by users, because we tend to see today users as consumers who have no obligations towards thinking what are they using, whether there are also some obligations, for example, obligation to update. If you have self-driving car, it's not what you do with your laptop today. You have this update blinking and you, not now, tell me again in 3 days. But you can't do that when you have a self-driving vehicle behind you, yes? You have to update. You can't postpone it. So I think we have to reimagine how the duties, responsibilities, rights and freedoms are going to redivide it between users, deployers, whether it's public or private sector, and then the producers. I think we need some innovation in terms of rule of law, human rights, and general law regarding that.
I like that innovation in terms of the rule of batteries. Or
to follow up a little bit on what Barbara was saying about the level of participation in decision making in moving towards certain new technological advancements. 10 years is so long. Probably there would be more than we can imagine in 10 years' time. But anyway, at the pace we are following right now.
But it's a long time.
Yeah, well, let's say 3-5 years or something of the kind. But I would imagine a number of impacts, that negative impacts on human rights even before that arrives. And that's why the consultation and the public participation, I think it is quite essential, having the civil society also to intervene. But something that we pay a lot of attention from the Office of the High Commissioner for Human Rights is also how we link everything we do to the SDGs and socio-economic rights. And I could imagine that this could create a lot of controversy in terms of jobs that could be lost if you automatize everything. And what happens? Are you creating new jobs that are related to technology to make up for those that could be lost? Or things like, for example, discrimination and equality. Would access be the same for everybody? Would this take into account the needs of certain groups or others? So I think that even before getting there could be room for a lot of discussion how to make sure that, and I'm not saying that it is necessarily bad, but all these things have to be looked into before we get to such a situation and ensuring participation, not only state and the private sector, but those us that are going to be then living in that world 10 years from now.
Yeah, thank you.
I'll catch on SDGs and other problems we are facing. We are not facing just these rapid technological changes as a problem. We have many other problems, and like climate change, and we can see in technology potential solution for that, and that's why we have this rapid process on the other side. So we also have like rapid urbanization and many other problems with cities, and that's why the question is relevant. So I see us going in that direction in order to optimize the consumption, to come to this sustainability level that we can survive. And implementation of these policies can take with it, like, can bring like many challenges. The challenge I want to focus on, regardless of the fact that I'm not conservative, but like, do we really have the option? So when we implement these kind of solutions, even if we have like proper impact assessment, even if we resolve the legal issues, do we have the option to stay out of these kind of systems? I think that's extremely important, because the trends are that we are not provided with the option. We are, like, billions of people are using Facebook daily, and they don't have option to pay it with money and with any other resource. They have to pay it with their personal data. In order to enter into new forms of economies, like collaborative economy, gig economy, you really need to provide a lot of data in order to create your personal profile, to get the reputation, because that's a prerequisite to participate on that marketplace or on that platform. So you have to abandon your own privacy in order to be part of the game. And we have more and more of these systems where we do not have option to exit at all in order to stay relevant and participate in trends which are coming. So it's not a vote for conservatives, but like, I would really like to have an option when I get old.
Thank you so much. Indeed, the right to opt out. I will move now forward, and I'd like to open this for questions from the floor to our panelists, if there are any on any of the issues that were raised. Yes, please.
Hello, hi. My name is Julia Haas. I'm with the Office of the Representative on Freedom of the Media. And we obviously work around a lot of the topics that were discussed today, a lot on the challenges, but also opportunities that technology poses to freedom of expression and freedom of the media. One important thing that we also work on is like the differentiation about which approach is needed for illegal versus harmful content online, which was also raised during this panel and also before. As far as understood from the discussions from the previous panels and also now, is that we don't really have an agreement on how we can tackle these issues, if we need more regulation, by whom, if we can refer to the businesses and human rights guidelines for companies. So maybe a different question, something that we also often struggle with, is the question of judicial oversight. So this is something that would be interesting to hear from you. What would, in your assessment, be the best to ensure that if we have, for example, content removal or decisions taken by algorithms, by technology, to ensure that there is judicial oversight, that we can also stick to the human rights legislation and frameworks that are in place? Thank you.
Thank you.
So I think that you are pointing to a really, really important question, which is about the content moderation, let's say, on social media platforms. And I think we really need to stick to existing standards on when the illegality and legality of the content should really be in the realm of judiciary. And human rights are designed with the view that they bind the states and that there is a judicial oversight or independent adjudication on the legality of the content. But what you are alluding to is also the content which the companies remove from their platforms because it's in violation of their community standards. And the community standards are not necessarily those which are illegal, because illegal content they need to remove anyhow, but the things for which they have a lower standard than what is allowed in the international law. So, for example, nudity, right? The nudity or pornography is not illegal in many countries. However, Facebook, Twitter can decide that they don't want this content on their platform and want to remove it, or they don't want to have profanities. It's legal to say profanities, but certain platforms say like no profanities on our side and we remove it. So what is a problem here then is the consistency of their approaches and also transparency of what they do, what content they remove, on what basis. And in this, we really need stronger guarantees for users and for the human rights protection, especially in the light what Georgia was saying, that it's often very difficult to remove yourself from these sites, and that's where often the life happens. They are de facto, public square where the freedom of expression is to a great, the great extent facilitated there and allowed. So for those, we really improvement of the accountability systems and content moderation, which are actually Article 19 is working on, and we are pushing for independent oversight and multi-stakeholder oversight over what these companies do in terms of content moderation, what content they remove, but also what they profile and how they set up their algorithm to what they show to their users. We call it social media councils, but it might not be that. At the end, it might be called something else that is also being proposed by Canadian government in their digital charter. So I think that this kind of initiatives deserve close attention and need a backing from the states, especially when we talk about really these dominant platforms which have a super dominant position on the market and really greatly moderate freedom of speech which happens online.
Just a small comment, because I think this question, rule of law, is important whether we talk about content moderation or we talk about new technologies. I'm a traditionalist in this sense. I think that, for example, European Convention of Human Rights was adopted as a living document. Yes, it should be always interpreted in terms of today. So rule of law necessarily necessitates that there are remedies. And remedies under Article 13 of the Convention necessitates that in addition to non-judicial different remedies, you always have to have a free, open door to a judicial court of law. So I do not see how rule of law can still be upheld without the last resort, at least, into the courts of law. And I think the question of how to achieve this has been around us for as long as we have had internet, because of the non-territorial character of the internet. And this is not going to change with the new disruptive technologies. These are going to be just as global, just as cross-border, just as cross-region as the internet companies today are. So whether we also find there some things as have been suggested, like internet courts by, for example, Judge Spano from the Court of Human Rights, or some other alternatives just introduced by Barbara, well, this is what the future will bring us to know. But we always have to, I think the rule of law is this last needle that we cannot drop, regardless of how many compromises we make in order for the new technologies to be usable and sustainable.
Indeed, I do wonder, however, considering the amount of data, the amount of content that algorithms are taking down. Now, for example, platforms such as Facebook are using, are outsourcing even this work. So there's one challenge I see, so the amount of data, the amount of content. And the other one is like, I do wonder about the user, say, in any country of the OSCE region, say, I don't know, Central Asia or South Caucasus. What is the real access to remedy that they would have if they have content removed or so on? But I want to open more for here, for if there are other questions from the audience. We do have 5 minutes left. So if there are no further questions, maybe yes? Oh, yes, please.
Thanks, I didn't even need to stand up. So Helen from the UK delegation. What you said about rule of law, and I think it links to the earlier session. We talked about risks of technology. So when we think of risks, we think of mitigation. And mitigation for us as officials will be rule of law, the courts, a legal process. and review and scrutiny and the involvement of civil society like yourselves. And it also sort of links again to what was said in the earlier session about liberal democracies trying their best and then being replicated by illiberal democracies. And I see the challenge is what do the liberal democracies do, and how do we address some of these challenges while trying to remain and with a human rights-centered approach to these challenges, relying on rule of law and courts process, which also I accept can be very slow, and this is another challenge for us as states, is either our internal processes or European processes are not the swiftest. But a lot of the focus has sort of been on that real challenge and negative, but also thinking about the positives of this. And actually, so it was trying to pull all those threads together. That there's a lot of challenge here, but you know, for us in terms of having confidence in our own systems and that transparency in that process. And so less a question, more an observation here. But also, while I've got the mic, because I might have to leave early to get home to my kids on a Friday afternoon, is actually talking about the positives of technology. So, you know, we've talked about the challenges from like CCTV, but the positives for civil society to challenge the state through that data, to challenge actions of law enforcement, through use of technology and body cameras and those kind of things. And actually there seems also to be a great deal of positive that could come out of technology for human rights and for civil society, and how state and civil society can work together to capture that. So if I don't have the chance to say that later, I've said it now. Thank you.
That's a very good point, but I think that when we talk about the remedies, and this is what I meant when I was making my opening remarks, that the remedies are also with the human rights design of these technologies, and that's actually, you know, quite a lot of need for support of these technical standard setting bodies to build the human rights into deployment, not just deployment, but also design. So bodies like Internet Engineering Task Force or IEEE or 3GPP, which is for the mobile network standards, or ITU, which basically deals with codes and telephone numbers. And there are very good initiatives, and this would also then provide the remedies when the human rights are built into these tech standards. And there are also the challenges, which is that, you know, they are not mandatory for the companies. And this is not like, you know, how companies should comply with certain legislation. This is how they build their products. And then also they are often made by those who just show up at the standard setting bodies, the companies which have enough resources to send engineers and who have money to engage. And then also it takes money and time and resources. So we really need, when we talk about the remedies and these issues, we really need a holistic approach, because the law and policies will not solve it. So we need to have all these parts put in place. And then we can have some hope into the really human rights-centered approach to this field.
On that note, are you more optimistic or pessimistic when it comes to, you know, the future technologies that are coming to the fourth industrial revolution? Just a few short remarks from all of you on to end this session. Start with Beatrice.
Question about being more optimistic or more pessimistic. There is something that actually I think we have not had the opportunity to cover. It is related to the rule of law, to whether there has to be judicial intervention or not, but also the whole responsibility does not lay only on the private sector, but also the responsibility of the government working with the private sector. And I just wanted to bring up two short things. One is how the technology has actually improved or make it easier for human rights workers like ourselves to do our work. For example, when monitoring, fact-finding, investigating, and so on, there are tools, obviously, that benefit the work that we do, but also in a perverse way, how it may be used by, and this is not the private sector, but rather governments to restrict civic space. And we've seen it in waves of protests that we are seeing now across the world. The first thing that happens, internet is shut down. There is no way that people can actually pass on information, and this is something that both the office and the special procedures report and cover quite often. And the last point that I wanted to make, which is related to how the governments can work with or the responsibility the governments have also in ensuring the private sector actually upholds the guiding principles and the framework that we have to work with, and invite all the participants here to join or to follow the Forum on Business and Human Rights that it is happening in November in Geneva. As you know, this is quite a huge endeavor every year. And it is about business in general, but there are a number of sessions that are going to be focusing particularly on ICT and how governments have a responsibility also in making sure the private sector abides by the existing framework, whether that is enough or not.
Thank you for that.
I'll just go a couple of decades forward, maybe, and talk about this fully automated society. Rapid technological change for me today is not really scientific progress and new solutions, new technologies, new hardware. It's really collecting all the data which are available, which are already there, and putting them on already existing infrastructure, in order to process it by smart algorithms and machine learning. And when we take that perspective, we need to understand that really investigating the results of fully automated systems is extremely hard. You need to have interdisciplinary team of different kind of experts from different kind of sciences, both social and technical, and there are a couple of examples of algorithms who made some mistake in a nanosecond and created like a loss of millions of dollars, and then this nanosecond have been investigated for a year and a half to understand what happened there. So just understanding that our capacity to reconstruct how the algorithms are making these decisions is really low. It's really important, because then we can't go too fast or we'll really break a lot of things.
Thanks.
Shortly, I would say I'm 200% optimistic and eager to see what new disruptive technology is going to make to our society. So, because I do firmly believe that no technology is never good or bad. The use cases are good or bad. And so my only call is, let's all embrace any technological advancement that happens in our societies. But I do call especially states and lawyers to drop being reactive and just be willing to jump into the game and make sure that the environment into which these technologies will dive into is comfortable enough for these technologies, but also for the rule of law and human rights to stay in the center.
Very realistic. So neither optimistic or pessimistic, because I know the limitations of the law, and especially lawyers. But what I'm a bit pessimistic about, and what I want to encourage, Karen already mentioned lawyers and legislators, but journalists, because when you read about the technology and artificial intelligence and so on, in the popular press, it's usually described in very sort of dystopian future with when robots are gonna take over and they will be deciding about our lives, rather than really discussing these really present and very real challenges which we have to human rights and privacy. And that's the stories they should bring to the people, so people really have an informed possibility of engage on how we want these technologies to be deployed by the states or by public administration, and also how we want to hold these administrations and companies to account for possible abuses. So I think the role for journalism and for public discourse and for investigative journalism, so on, is really huge and underused.
Thank you so much. So let's get in the game on technological development. Thank you so much for our panelists for the interesting talk. And I'm passing on.
Thanks very much. Just to say that there's a 10-minute coffee break. We really need to start punctually at 4 because the last panel is our shortest anyway by 15 minutes. So please enjoy the coffee, but come back at 4. Thanks.